Deal with that.
We are back on Morning Line. Thanks for joining us. We're talking this morning about the Supreme Court decision specifically, and I apologize for this. I know you had a lot more you wanted to talk about, but this is where the callers are going to on the same-sex marriage, and you've got a lot of interest in that as well as you followed these Supreme Court cases. Professor Blumstein from over at Vanderbilt with us. Let's go back now to Philip. Philip, what's your take?
Okay. My ultimate take is no man's law will ever supersede God's law.
Now, whose God are you talking about?
Who's God?
Yeah, is it your God or someone else's? I'm just curious which God you're talking about.
The only God that there is.
Okay, so only yours, not people who worship other gods, perhaps. Is that it?
There is but one God.
Just yours. Okay, sounds good. Go ahead.
Christ and whatever. Look, Nick was talking about, this is ridiculous, trees, and you mentioned whatever.
Dogs.
You can talk about, marrying a frisbee or whatever you want to talk about. Let's keep it with human beings here. And I'm using your logic. I'm using the gay agenda's logic that who is anyone to define or say who can love who? So how can this not lead to, if children are allowed to pronounce that they are homosexual or that they are transgendered and we must respect their decisions, who are y'all to say that they cannot marry at the age they want? Who are y'all to say that a man cannot have multiple wives anywhere in this country, in any state? Who are y'all to say that a woman cannot have multiple husbands? I mean, y'all are the ones saying no one has a right to define what love is, and anybody can love anybody they want to and get married. So how hypocritical and I'm not a proponent of lifestyles like that, but how hypocritical for the homosexual community to say that America must recognize two men loving each other and getting married, but on the same tune, we won't allow multiple women to love the same man and live as one in loving harmony, family lifestyle that they want to live.
Okay, do you think it can come to that?
Well, I mean, that's what I said. I think that's going to be one of the next issues that's going to arise, and I think the caller makes a strong point. I think this is one of the weaknesses of the Supreme Court's opinion, is that it doesn't sharply draw a distinction. Now, I think at the end of the day, the court is worried about harm. The court concluded that its ruling would not harm anyone, would not harm the institution of marriage, it would not harm children, and that this was just a personal preference and it was an opportunity to marry that would be beneficial to some and not harmful to anyone. When you get to multiple partners, polyamory, I think it's an open question whether
now, are there bigamy laws that would be superseded by this? Now, we obviously know there's statutory rape laws and children getting married, and we know there's bestiality laws.
Yeah, children is a different story.
Those types of things are already against the law, and as you said, a certain degree of common sense has to come into play. Now, the bigamy issue, there's laws. I can't go out and marry 5 women. Right. That's against the law.
And that's what the caller is saying, is that they would be subject to challenge. And there are some in the gay community. I don't think it's the majority by any means, but there's some voices in the gay community that are sympathetic to the polyamory, to the polygamy idea. That's going to be the next question. Now, that will be a legitimate issue. Say a Muslim family or a Mormon family that wants to have multiple partners. That issue will be out there, and then it'll be put to the test whether there's a meaningful difference between that situation and what the court ruled on in this case. Now, with respect to children, that's a different story. That's really been up to the states to define what the age of consent is and when you can marry. In some states it goes down to, I think, as low as 14, other states 18. That's up to states, and it's traditional, and the assumption is that when people are able to have consent, reasoned consent, then the law should respect those judgments. But with respect to children,
there's a state in this union that allows a 14-year-old to get married. What's wrong with the people in that state? Don't tell me a 14-year-old knows what they're doing getting married. It's ridiculous.
Not sure. Strike that. I think that's right. I'm not asserting that.
Okay, but I'm sure there had been. That's those laws are on the books for a reason. Protect children.
16, 18, that's the more normal.
There you go. Right. Let's go to Tony. Hi, Tony.
Good morning, Dave.
Morning, Tony.
Thanks for taking my call. I try to listen to everybody. Some of these calls I hear them at night when your show is on. So I try to give them space to get their point across and later comment. There's only two things I want to say. One is, first of all, why are they coming to the legislature trying to make a law to protect the priests and the church and all that if they're already covered under the law for not refusing to marry these people? And number two, I get heated and angry every time I hear gay people and the gay advocates say it's the same as the civil rights people of the 60s. I can't change my color. I'm black. I can't go around here and change things about my identity. And it just makes me angry with these professors and these talking heads on these TV shows saying that. That's not the same. That's not the same right as somebody black, a different origin, or this homosexual court stuff. I don't understand why these people keep saying that. And it makes black people look silly, and it makes them determined to stop this stuff when they keep saying that. You can't compare that to murderers and killers, for being your race and being hung in a tree. It's none of these people that went through that.
Oh, I see what you're saying. Okay.
Yeah, this is an important issue. Every new group that seeks to be recognized and have its civil rights recognized is trying to fall within the mantle that has existed for the civil rights revolution, which was prompted by discrimination, horrible discrimination against blacks. Women did this, and religious minorities have attempted to do this, and now the gay community. Now, one of the important intellectual developments that Justice Kennedy pointed to is evidence, and I'm not qualified to answer this, but I can just say what the issue is. Whether or not one's status as homosexual is an immutable characteristic like skin color, and the gay community, as part of its advocacy, and started making lots of progress when they put forward studies that showed that this was not a choice, but this was a trait that you're born with, and changing one's behavior is at odds with who you are, so to speak. Now, again, I'm not qualified to answer that question, but the court seemed to assume that that was accurate, at least the majority did, and therefore that makes this civil rights argument stronger, as this caller would say. But each group that has faced discrimination has special characteristics, and I think each group must make its claim for fair treatment based upon its own circumstances and society's treatment of them. And certainly in this country, the caller is quite right that the discrimination, the slavery that was our history, and Jim Crow after slavery puts blacks in a special category, so there's no doubt about that. But I think it's also from the point of view of the gay community, the women, others who are seeking to get the mantle of civil rights advocacy are trying to fall within that broad umbrella, but it is in fact not the same thing. But the question is, how closely analogous is it? Should the society bring out the same notion of non-discrimination? And that's what the court was finding here. Interestingly, the court did not rule that gays as a class cannot be treated differently. What it said was, in the context of marriage, gays cannot be treated differently. And so while this case is very, very broad, it's also very narrow. And so there is nothing in this case that says that government must employ gays on a non-discriminatory basis. Now, the Equal Employment Opportunity Commission has said this is a form of sex discrimination, and whether that will withstand scrutiny or not is an interesting question. Many are dubious about that, and that reflects kind of pushing the envelope. But this case does not focus on gays per se or the status of gayness, unlike the cases involving blacks, where they're called a suspect classification, so that if government rules based on race, then the government is put to the highest level of justification. The court did not say that discrimination against gays involves a suspect category the way it is true with race. So there's very different. This was a marriage case, not a gay case.
But as you said, who knows? There are other hurdles for the gay community to go after, and how they handle this victory may dictate whether or not they have other success there. If they alienate more beyond, like I said, the end zone dance. You're going to push and go after religion, which may not be the best move if they have other things on their agenda.
And on issues like performing of marriages, even performing of services. Now, that is not a constitutional claim, very likely. If you are in the business world, non-discrimination rules can apply to you, especially in areas of public accommodation. But if in practical terms, and this is what the Hobby Lobby case dealt with, in practical terms, if it would violate your faith tradition, even if you're in a business, if it's a closely held company, the Religious Freedom Restoration Act does recognize that the government has to have strong justification to infringe upon, so substantially infringe upon your religious exercise. Now, if access becomes a problem, if people who are gay or married can't find people to plan their weddings, or if they can't find people to bake the cake at their weddings, if that really is a practical matter, forecloses their opportunities, then that's a different story. But if you're in a big community and there's one religious baker that doesn't want to do this, and you want that baker, then I think you strike the balance in a different direction.
I couldn't agree with you more. Just use a lot of times, and you say this, common sense. Professor, thank you.
Thank you.
Thank you for coming on. And you know what? We covered one Supreme Court decision. There were many others. We'll focus on others.
I brought a bunch more, but
we will talk again, my friend. Listen, thank you again. This was very interesting, and I appreciate all the calls. Sorry we didn't get to them all, but we'll see you again. Take a break. Programming note about tomorrow right after this. That hour went quick.